Hello, everybody. My name is Christopher Cole, and because I'm recording this in January of 2017, I'm the first vice chair of the Pima County Libertarian Party. Today, I'd like to talk about the U.S. Constitution. There's a lot of talk, and it's been going on for a long time, that the Constitution is a living document subject to the interpretation of the federal government. If you got a mortgage, would you accept the fact that your mortgage holder says, oh, well, your mortgage is a living document and we can interpret it however we want? Why then do you allow the federal government to interpret the federal Constitution to its benefit? There's two ways of changing the Constitution. Two ways to amend the Constitution. Those people who say, oh, it's a living document and we can interpret it however we want, they're imposing a third way, a very non-constitutional, indeed anti-constitutional way of amending the Constitution. And they never do it for your benefit. It's always for the federal government's benefit. You're left out of the equation. The federal Constitution is a legal document. The language used is that of 1787. The spelling and punctuation is that of 1787. But we know what the Founding Fathers meant. We know what they intended. Why? How? The Federalist Papers. Those papers, little essays and letters that were written to argue in favor of the federal Constitution. And they paint a very clear picture as to what the Founding Fathers intended, what the Founding Fathers wanted the federal government to be. And if the Founding Fathers saw the federal government that we have in place today, they would be appalled. King George III and Lord North, they would love it. You know, the people that we rebelled against in 1776 because their government was too arbitrary, too capricious, too out of touch. They would love our federal government. The federal government pays, at best, lip service to the federal Constitution. The federal Constitution is more than just the organizational document for the federal government. It's a protection for you. It is a protection for you to keep you protected from the government. The federal Constitution is supposed to protect you from a bunch of black-clad policemen bursting down your door, charging in with flashbang grenades, killing your kids, your dog, whatever, on the off chance that you got marijuana or some other prescribed drug. And the only reason they're doing that is somebody told them. They have no idea if the other person, that the snitch, is telling the truth. They don't care. The federal Constitution is supposed to protect you from that. And we know from what the Founding Fathers said in the Federalist Papers, that's what they meant. But it's a living document. We can adjust it and interpret it however we want. And so the Supreme Court said, Well, the off chance that evidence might possibly be destroyed is enough to ignore the protections of the Fourth Amendment. Really? The convenience of the government has more import to the federal government than your rights do? Think about that. It's obviously true. Since when does the federal government not act in its own best interests? And its own best interests are accumulating power. That's what it sees as its own best interest. In the federal Constitution, that wonderful legal document is supposed to protect us from that. And all of those protections are being stripped away by those who say, oh, we interpret the Constitution this way because it's a living document. Well, they're full of it. Or as my mother used to say, you're full of condensed horse milk. I like that phrase. The federal government is a legal document designed to protect your rights. Not give you rights, but to protect your rights. And the arbitrary interpretation of the Constitution by the federal government destroys your rights. So, unless you honestly look at both sides of an issue, you don't have an opinion, you're a parrot.